Good afternoon, everybody. My name is Travis Rutherford. This week, I'm going to be talking about the plea bargaining process. So, plea bargaining process is really an inherent part of the criminal justice system. Um, Plea bargain is essentially negotiated agreement between prosecution and defense, where the defendant will agree to plead guilty to a lesser charge, often in exchange for more lenient sentence or the complete dropping of other charges associated. The process serves a few different purposes, including judicial efficiency by avoiding the lengthy, costly traits that come along with trial processes. Usually begins after a criminal charge has been filed, but before the formal trial actually occurs. The defense and the prosecution engage in discussions, kind of talk about what they want to see from one side, what the other side will agree to, back and forth, until they ultimately come up with a good solid agreement. And the judge actually has the discretion to accept or reject the terms of the plea bargain. Although most of the time they are usually accepted because it, again, alleviates that trial process. For the plea bargain to be valid in the court of law, there needs to be a few elements present. First one, the defendant must voluntarily agree to the plea bargain, essentially. So they can't be coerced into it. This actually was brought up in the case United States v. Tateo. Defendant pleaded guilty only after hearing what the judge was ultimately going to decide if they were found guilty during trial. Hearing this, the defendant actually pleaded guilty and accepted a plea bargain. It was fought back years later, but essentially the sentencing stood. So the judge's role in this whole process varies. Different judges have different views, different ways of running their courts. The role of the judge is pretty much an impartial overseer that'll listen to both sides, kind of guide them the proper route that they think they need to go. And I'm going to quote here, according to Beal from 1977, some judges merely accept or reject the prosecutor's recommendations passively without any advance indication. Others actively intervene in the negotiating stage to encourage disposition, end quote. So this pretty much means, like I was saying, some judges are active, some are passive, some have more to say than others. It just kind of depends. But their main purpose is I am either approving this or rejecting it, essentially. So for myself, this is an interesting topic. During my research, I knew I didn't know a lot about it. But I do believe there are flaws and ethical concerns, I guess, that would need to be addressed before officially taking one side. But I believe policymakers have made various attempts to manipulate, I guess, the defendant in certain cases to get them to accept the charges and ultimately avoid the trial time, the cost, and all that. I do believe it raises some ethical concerns about whether justice is actually being served in this instance. And there's also the issue of potential disparity in legal representation. So you got individuals who can't afford the legal counsel that has that experience, that knowledge, years under their belts to know how to strike the proper deal, stuff like that. And that can lean towards disparities in the system. It can potentially serve as practical and expedient tool, but again, it depends on the system put in place. But my personal belief is I'm not a fan of it. I think everyone should have their right to trial by jury, right to speedy trial. Those amendments that essentially you would waive if you were to accept a plea bargain. And I mean, what's the point of having those rights if you're just going to waive them away, So that's really all I have. That's my stance. That's my discussion. Looking forward to the comments. Thank you.